Well, welcome everyone. Hello there, and thank you so much for joining me on this live stream session. My name is Lior Samfiru. They call me the employment lawyer, and you're watching your employment law session. This is your live stream employment law session where you get to get questions answered. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And my firm, we can help you in Alberta, in BC, in Ontario. We got your back. We got you covered. We got answers. We got help. We got solutions. And it can start right now, right here. If you're watching and you want to know about your workplace rights, if you want to know about employment law, if you want to try to get some help with your workplace situation, ask the question. Maybe you're wondering if your boss is allowed to do something. Maybe your boss has given you some sort of an ultimatum. They want you to sign something, to agree to something. Should you? Should you not? What does that mean? Maybe you're being mistreated in the workplace, some harassment, some bullying. You're dealing with a poison work environment. Who do you speak to? What do you do? What does the law do? Ask the question. And of course, like so many people recently, if you've lost your job and you want to understand your rights, definitely ask your questions. You have rights. We have some of the best employment law rights in the world right here in this country. So if you want to know what the rights that you have are, if you want to get some questions answered and some help, some advice, ask the question. I'll answer it. I'll tell you, and you can walk away with the knowledge that you need to have. Now, before we get started with questions, let's get you some other contact information. If you want to reach me and my team to have a private email exchange or a conversation, a consultation, easy to do. You just go to employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca. And when you're there, if you want to, you can also learn a lot more about all your employment law rights. We can call you if you prefer to fill out a form. All your one-stop shop when it comes to employment law is right there at employmentlawyer.ca. But right now, you can ask a question. You can tell me what you want to know, what you're dealing with, and get my thoughts on that. So take advantage of that. I'm here for you, right? I could be doing other things, but I want to be here. I want to be answering your questions and helping you out. So don't be bashful. There's really no bad questions. Sometimes people say to me, I just didn't want to ask a question. I didn't think if it was a good question. There's no such thing as bad questions, only good questions. So ask your question right now. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I'm going to start doing right now what I came here to do, which is answer your questions. But as you're listening to me answer and listening to me talk, type in your question, hit enter, and it will pop up on my screen, and I'll read it, and I'll answer it. All right, let's get going. What do you say? First question of the day, in bright and early, is Massive General. Massive General has a question. I work at a fast food restaurant, and most times we're not able to clock out at the exact time our shift ends due to a number of orders. My manager is always insisting that we finish what we've started, even though it is past our time. They also require us to have mandatory in-person meetings every month that is outside of our schedule, and we do not get paid for this time. We feel we've been taken advantage of. What can I do? So if you're an hourly employee, okay, you have to get paid for all work time, whether it's staying late, whether it's coming in for a mandatory meeting. You have to get paid. There's no such thing as requiring you to do something and not paying you for that. Now, it'd be different if you're on a salary because you're getting a flat amount, but if you're paid by the hour based on your time, you have to get paid for all work. So what happens in those situations? Well, you can tell your employer, I'm not going to do it. Sorry, I'm out when I'm out, and I'm not going to come to these meetings unless paid. They can't punish you for that. Legally, they cannot let you go or punish you because you're standing up for your rights. But you have to always think, what is that going to do to the work environment? You have to consider that. But legally, that is absolutely your right. Okay, and if you've attended these meetings, or you've worked extra hours and you haven't gotten paid, you can also file a complaint with the Ministry of Labor, with employment standards, to get paid for that money, that outstanding amount of money. You can go back as far as 2 years. So those are your rights. There's no such thing as free labor. It doesn't exist, all right? You don't volunteer your time. You're not being told, you can't be told to do something, to show up, to spend time unless you're paid for it. So hopefully that makes sense. Any follow-up questions, I'm still here. Feel free to answer them or ask them. I'll answer them. How about that? So that's our first question of the day. See how easy it is. See how simple it is to get your question answered. If you've just joined us and you're wondering what is this going on here, well, first of all, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And this is my live stream session. You get me here for 30 minutes answering questions live, your questions about your rights, your workplace. So there's no better time to get answers than right now. So ask your question. No need to wait. You got time. You can get an answer. And I'm going to continue answering right now. Let's see our next question here today. Another one from YouTube. This one from Philip. Our Toronto company was bought over by Americans, but their execs work from the Toronto office. Are American employees working in Canada protected by our laws as it is based here? So yes, if you physically work in Canada or in Ontario, whatever province, it's the laws of that province that apply to you. If your regular work is, say, in Ontario, doesn't matter where you're otherwise based out of. If you're legally working in Ontario, even if the company is not a Canadian company, Ontario laws apply to you. And that is a great thing, because guess what? We have much better employment laws in Canada than they do in the US. You don't have the same protections in the US as you have in Canada. You don't have the same protections against constructive dismissal, against temporary layoff. You don't have the same rights to severance. So yes, if you're physically working in Canada, those are the laws that apply to you. So remember, the fact that the company is based out of the US or Europe or Asia, none of that matters. The laws of that jurisdiction do not matter. The laws of the jurisdiction that apply to you is the laws of the jurisdiction where you're actually physically working. Whether you're working in the office or working remotely from your home, those are the laws in that jurisdiction that apply to you. So very important. And sometimes companies don't understand that. Some companies may say, well, we're an American company, you work remotely, so it doesn't matter. So American laws apply to us. No, absolutely not. If you have employees in Canada, the employees are located here, those are the laws that apply. And like I said, for an employee, man, that's a very, very, very good thing. You don't have the same rights in the U.S. I'm not so sure about Europe, but certainly in the U.S. you don't have the same rights. All right, fantastic question. Thank you for that. Really, really good question. If you just joined us and you're wondering why I'm talking about these things, well, because I'm the employment lawyer. My name is Lior Samfiru, and this is my live stream session where I answer your questions, everything you wanted to know about your workplace rights, about employment law, about your job security, your severance, your wrongful dismissal, constructive dismissal, you name it. All right, questions have come in. I see them, but please keep them coming in. I want to be even busier than this. I'm going to start answering or continue answering right now. I'm going to get to your question, so ask it. Long Jump, great name. Long Jump has our next question. I was terminated after providing notice to go on maternity leave beginning mid-March. I was offered 12-week severance after being a senior employee for 4 years. My contract also has a severance schedule based on year of service. This wasn't honored. It would entitle me to 5 to 6 months of pay. Should I accept the offer? They're only giving me a week to respond. Well, I think you already know the answer, right? I can't imagine why for any reason you would think that you should be accepting this. So let's break this down. So before I even talk about severance here, the biggest issue that's, of course, jumping at me is you're telling them, hey, I'm going on maternity leave. Okay, you're let go. Wait a second. You can't do that. All right? You can't let someone go when they're about to take a parental leave, when they're advising you of that. The only time you can let someone go is if it's completely unrelated. Let's say they shut down the whole department and let everyone go in the department. Well, they can let you go too, even though you're about to go on a leave. But beyond that, no, they can't. So this could easily be an employment standards violation. It could be a human rights violation. It could be quite illegal. You can't do that. And the company would have to prove that it was unrelated. And I think with that timing, it may be very difficult to do. So right off the bat, we have a huge issue with the human rights violation. The second issue, even if we put aside this human rights violation, is that of severance. Now, I haven't seen your employment agreement. Maybe it limits you to 5 to 6 months, but that's a lot more than the 12 weeks that you've been offered. And it's quite possible that you're owed even more than the 5 to 6 months that's in your employment agreement. I don't know your age or the type of job that you were doing. I just know that you were there for 4 years. You could easily be owed 8 months, even 9 months of severance. So, no, you should not, under any circumstances, accept the 12 weeks. Of course, also because it's a human rights violation potentially. So there's a lot of wrong things going on here, long jump. So what you need to do, of course, easy. You got to reach out to me. I want to meet with you or have a chat, private chat, understand more about when you told them about the leave, why they're letting you go. I want to see that employment agreement. So we have a lot to discuss. So long jump, you know how to reach me. Very easy. Employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen. Take advantage of it, use it, and let's have that chat. Okay, long answer, but really important question. I wanted to make sure I covered all the issues. So that's why you ask these questions, because you may not realize just how many rights you have, how many violations potentially you're facing if your employer did something. You can ask the question. Again, I'm Lior Samfiru, the employment lawyer. If your employer is doing something, it's something in the back of your head is telling you, yeah, I don't know that that's right. You're probably correct, and it potentially is even worse than you thought. And just ask the question right now, and I'll tell you, I'll help you make sense of it. So take advantage of me being here. Again, Lior Samfiru, the employment lawyer. Let's get going to answer even more questions. Next question is from Saga World Boss, who says, if your workplace closes down, when do they have to tell employees, and would we get paid out if that happens? So they tell you when they tell you. It's a question of, if you lost your job, you're owed severance. Now, if you've gotten advance notice in writing that you're losing your job, the amount of notice that you got counts towards your severance. I'll give you an example. Let's say you're owed 10 months of severance, but you got 3 months notice that you're losing your job because you're closing down. Well, that 3 months counts towards your 10-month severance, which means they still owe you another 7 months. Okay, so hopefully that makes sense. If you've got no notice, that they have to pay your full severance. If you know the company's shutting down, if you know the company's about to let you go, we need to talk right away. We want to deal with that as soon as possible. All right. So for you, by the way, Saga World Boss, for anyone else, if you want to find out actually how much severance you're owed, they're shutting down, they're going to let me go, what am I owed? Very easy. To find out right now how much severance you're owed, so easy. You just go to pocketemploymentlawyer.ca. You see that address on the screen. It's pocketemploymentlawyer.ca. You use your smartphone, your tablet, your desktop, doesn't matter. When you're at pocketemploymentlawyer.ca, click on the severance calculator. That's it. You're right there now. You can answer some questions, and it's going to calculate for you how much severance you are owed. By the way, spoiler alert, it's not a week per year. It's not 2 weeks per year. It's much more. All right. Check it out. It's completely free, completely anonymous. It's just there for you and your benefit. Take advantage of it. Okay. Pocketemploymentlawyer.ca. Click on the severance calculator. Use it always. Maybe you're curious what would happen. Maybe you've actually lost your job or getting ready to lose your job. You got to go there. Pocketemploymentlawyer.ca. Use the severance calculator. All right. Thank you for that question. I see more questions have come in. If you haven't asked yours, what are you waiting for? Let's do this. You got time. You can ask your question, then sit back and relax and let me answer it. Again, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP. And let's get to our next question, which is from Beverly. Beverly says, I was terminated after telling my manager I had a learning disability and the job they moved me to was challenging and that I needed extra help. They said they had planned on firing me 3 days before. I wasn't even there long enough to get a chance to try. So at the end of the day, it's not even a question of whether or not you had a chance. It's a question of whether or not they're letting you go because you have a disability. If they say, well, we don't want people that have a disability here, that could be a human rights violation. If that's not why, it just happened to coincide, then it becomes an issue of severance. Company is not required to give you a particular amount of time. What they're required to do is to pay you your full severance if they let you go. good reason, bad reason, they have to pay you your severance. Of course, the exception is they can't let you go because of a disability. If you have a disability, then you cannot be let go because of it. So if you're not let go because of it, it's really a question of severance. And I can almost guarantee you, Beverly, almost guarantee you that if they've offered you something, whatever they've offered you is a heck of a lot less than what you're actually owed. So you can go right now, as I mentioned before, Beverly, you can go to pocketemploymentlawyer.ca and click on that severance calculator and actually see how much you're owed. Or if you want, you can even tell me right now what your age was or what your age is, how long you've worked there, and the type of job that you have, and I'll tell you how much severance you're owed. You can also contact me in the office so I can help you get what you're owed at employmentlawyer.ca. Hopefully that makes sense. And if you have any follow-up questions, I'm right here. Severance, you have to focus on that because you could be owed months and months and months of severance. All right, let's see. More questions have come in. Let's get to it. Ellie has our next question. My employer has reduced my commission structure. I work in sales and has given me 10 months notice, during which my pay remains unchanged from the period before the decrease. I have been with the company for 18 years. Once the 10-month period ends, can they terminate my employment without severance? I'm 49 years old and I live in Ontario. So to the extent that they make a significant change to the terms of employment, that is what we call a constructive dismissal. All right. And what I mean by that is by changing your terms of employment, that could be considered by you as a termination of employment. Now, what they've done is they're saying it's not effective now, it's effective 10 months from now. Well, those 10 months count towards your termination entitlements. So in your case, Ellie, you say that, let's see, you're 49 years of age, 18 years, you're probably owed right around 16 months of severance, about 16 months. So that means that they give you 10 months notice, but they still owe you about 6 months, okay? And to make up that difference. So if in 10 months you choose not to accept this reduction, you choose to consider that a termination. So they're not terminating, you would be the one choosing to consider this a termination. At that point, they'd still owe you that difference, about another 6 months pay. Now, there's a couple of things we can do in the meantime so that they don't get credit for those 10 months. I can help you with that so that they would have to pay you the full 16 months down the road. So let's discuss that off air. You can reach me, Ellie, through employmentlawyer.ca. Again, employmentlawyer.ca, and I'll help you do that. Again, reach me. Let's talk about that. But I think you understand what I mean. A significant change like reducing your commission, reducing your pay, reducing your hours, any of those could easily be a constructive dismissal. Okay, Ellie, thank you for that. Reach me through employmentlawyer.ca. I see more questions. I'm going to answer them. But a reminder here that I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I want to continue doing and going to continue doing what I've been doing for the last 17 minutes or so, which is to answer your questions here live about employment law, about workplace rights, about your job, your compensation, etc. So you still have time. We still have plenty of time. This session is not over. So ask your questions. Give me that chance to help you. And let's make sure that when you go into the weekend, you'll feel a lot better than you feel right now because you know more about your rights. You understand them better. So ask your question. All right, let's see. Fulgan, and I apologize if I mispronounced the name, has our next question. I was terminated after 7 years of service in Ontario and paid my severance per the Employment Standards Act. My contract does not have a termination clause. Am I eligible for common law severance? What can I expect? Of course, every employee is entitled to a common law severance unless you sign an employment agreement that gets rid of it. So yes, of course, you're owed that. Now, Falcon, I don't know the type of job that you have, and I don't know your age, but it could easily be anywhere from 6 months to 10 months, maybe even more if you're older or a more senior role. So in the range of 6 to 10, depending on your age and the type of job. So you've been offered a lot. If you've been paid employment standards minimums, that's a heck of a lot less than that. So you're owed significantly more. So let's have that discussion. Probably 80% of what my team and I do is help people get their full termination entitlements. Help them make sure that they get everything that they're owed if they lost their job. So Falgun, you know what to do. You got to reach me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. The address is right there, right there. You see that? Employmentlawyer.ca. Phone number is there. Email address is there. Let's get going. Let's get you what you're owed, okay? Any follow-up questions, you know how to reach me. I'm still here. You have time. So let's continue that conversation. Right now, though, still live, and I want to answer even more questions. You have the opportunity and the time to ask it right now. Don't ask it right at the end. Usually, just as I say, guys, this was a great session. Thank you. I get questions popping up on my screen, and I don't get to answer them. Don't do that right now. If you ask it right now, my guarantee to you, you'll get an answer. All right, so let's continue with our next question, and that comes from VQ. VQ says, my sister just got a job working for a big company. Her husband works for the same company. He gets all of Sundays off and always has. When my sister got the job, she was told the new policy is that they only give a half day off for religious reasons. They said he had the job before the change and thus had the old policy grandfathered. Does she have any rights here? Well, no. If it's not unreasonable to have, well, I mean, listen, if you have some sort of a letter from a minister, a priest saying you cannot work on Sundays for a religious reason, you follow that religion, they have to accommodate. Okay, it's not up to them. I'm not an expert on religious requirements in the sense that I don't know if there's a prohibition on you from working on Sunday. The fact that they do that for the husband doesn't mean they have to do that for the wife. It's a question of, is there a religious reason that's corroborated by some sort of a religious leader that says can't work on Sunday for religious reasons? If you have that and provided to them, they have to accommodate. You cannot be refused accommodation based on religious grounds. That would be a human rights violation. So minister, priest, reverend, whoever the right religious leader is for your sister and her belief and her religion, if she can get that in writing, her employer must accommodate. Now, I don't know if it's one of those things where you can work half day, you can't work the rest of it, but that religious leader, if you get a note, you have to be accommodated. That's an important reminder here. When it comes to accommodation, an employer has an obligation to do it. We usually see that in the context of medical accommodation. Someone has a limitation, a medical limitation, and the employer has to accommodate modified hours or modified duties, maybe to work from home. An employer must do that as long as that is corroborated by a doctor or a doctor's note. So if your doctor says, hey, for medical reasons, you have to work from home, your employer has to find a way to accommodate you. Or if your employer or your doctor says that for medical reasons, you cannot work more than 20 hours a week or you need modified duties, your employer has to find a way to make that happen. But it starts with that doctor's note for medical accommodation. For religious accommodation, well, not a doctor, of course, we will need the appropriate religious leader to provide something in writing, and that would trigger the employer's accommodation obligation. Hopefully that makes sense. Anything that you're not clear or anything you want to discuss further, just ask the question. I'll be happy to talk to you. All right, let's see. Let's continue answering questions. You still have time. Guys, you got to keep me even busier than this. I can take on even more questions. Don't be worried about me. I love taking questions. Next question to us right now is from Sarm. I was terminated without cause 3 weeks before the end of my 6-month probation period after 5 months and 1 week. I am 3 months pregnant as well, but did not disclose this, so I may find it difficult to find new employment. I have received a letter giving me 1 week of severance. Am I entitled to more? Absolutely, yes. And you're going to be entitled to more no matter what. Now, first of all, even if we put the pregnancy issue aside for a second, after 5, almost 6 months of employment, depending on your age and the type of job that you had, you could be owed anywhere from 2 to 6 months of severance. 2 to 6 months. Yeah, that's true that you may have worked for 6 months and you could be owed 6 months severance. So absolutely. Now, the fact that you're pregnant, and that means you're not going to be able to find another job right away, it's going to be very tough. That means you're going to get even more severance. The idea behind severance is to help carry you until you should be able to find another job. Well, if it's going to be harder or take you longer to find another job, that means you're going to get even more severance. Okay, very important to remember that. So the fact that you're pregnant, regardless of what your employer knows, is going to mean more severance. So, sorry, you got to call me. Okay, you're owed a heck of a lot more than a week's pay. You're owed several months of pay. Okay, months. So we need to have that discussion as soon as possible. We need to have a chat about that. This is a good time to remind you that short service employees, short service, and what I mean by short service is employees with 5 years seniority or less, are treated disproportionately better than longer service employees. So an employee that's worked for 2 years could easily be owed 5, 6, 8, even 10 months of severance. Okay, too many people assume, well, I only work for a few months or for a year, so I'm probably not owed much. Maybe I'm owed a week's pay, maybe 2 weeks' pay if I'm lucky. No, short service employees are treated very, very well when it comes to severance. The reason for that is just because you work for a short period of time doesn't mean it's going to be easy to find another job. In fact, it may be more difficult to find another job because you have to explain why you only worked for the last company for 10 months. So that's why short service employees get a significant amount of severance. So it doesn't matter if you work for 2 months, 20 months, 5 years, you got to call me. Okay, you'll be surprised by how much you're owed if you lost your job. Give me that call. All the contact information you can find at employmentlawyer.ca. Again, employmentlawyer.ca. Again, I'm Lior Samfiru. If you've just joined me, the employment lawyer, want to take some more questions. You got some time to get your questions in under the wire. So let's see what you can ask me and what I can answer. Philip has our next question. Philip says, last year, we were given documents to sign regarding return to the office with new terms of employment. Are those documents valid if I never received anything for signing them? Yes, they're valid. And you did receive something, right? Because you received new terms of employment. So if you sign them, it's very likely valid. Even if it's, what happens, you're going to return to the office. Something new happened here, like a return to the office. So a contract or employment agreement is not valid as if nothing changes. You used to work 9 to 5 in the office, doing a certain job. You sign an agreement, but you still do the same job 9 to 5. That agreement is not going to be valid because you got nothing. Nothing has changed for you. But if in this case something's changed, or some new terms of employment, you're now going to be in the office, it's probably valid. But I want to remind everyone here that in most cases, if you've been working remotely for a long time and your employer wants you to come in now to say, well, too bad, you're not going to work remotely the same way anymore. We want you to come in. In most cases, if you refuse, the company can still let you go, but they're going to have to pay you severance. That's not considered a resignation or a job abandonment. That's not a basis to terminate you for cause. They would have to pay your full severance. And depending how long you've worked there and a few other factors, that severance can be as much as 24 months pay. All right, so keep that in mind. But best advice I'll give you, Philip, and anyone else, if your employer wants you to sign a new employment agreement, man, do not do so without speaking to me first. Do not do so. And to reach me, of course, employmentlawyer.ca. Let's see. Let's take one more question here. Bolo has our next question. Bolo, I've been working for this company for the last 2 years. I suddenly received notice that my working hours will be reduced from 40 to 28 per week for the next month due to a slowdown. I also noticed that only 2 of us out of the 3 in the same department received a reduction in hours, and all 3 of us have the same job description. Is it legal to reduce working hours temporarily without notice ahead of time? Well, no, it's not. That could be a constructive dismissal. So ultimately, what you have to decide is what is better. Is it better to continue working and hopefully they move you back up in a month or however long it is, or to say, no, I'd rather not work here and I'd rather get my severance? Those are the decisions you have to make. So one of the things you can do is to say, hey, let's see what happens in a month. I'm not happy about it, but if it's only a month, I'll live with it. As long as in a month, they bring me back to normal. So you can tell your employer, I'm not happy, but I'm taking your word for it that in a month I'm going back to normal. If they bring you back to normal, fine. If they do not, you can still say at that point it's a constructive dismissal. All right. So you have to make the decision. If you want to pursue a constructive dismissal, don't walk away. Don't tell your employer to go jump in the lake. call me. Okay, let's have that discussion. Let's dot our I's and cross our T's, and you can reach me through employmentlawyer.ca. So thank you for that question, Bolo. Those are the questions that we had for today, and that's the time that we had for this session. Thank you, by the way, so much for joining me. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. I love doing these sessions. I'll be back again soon, but don't wait for me to be back. Don't wait for my colleagues to be doing this. Just reach me in the office, my team. We can have a private discussion. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team and have that private discussion. So don't hesitate. Take advantage. We're here to help. Everyone, I hope you have a fantastic weekend. Thank you so much for joining me, and we'll talk again soon. Take care.